Good morning, everyone. Thank you for joining us today. It's 10 o'clock, so we're going to get started. My name is Dinal Gopal, and I'm an HR consultant at HR Talk. So before we begin, I'd like to welcome you all on this lovely Wednesday morning to talk about harassment in the workplace. All right. We will keep questions to the end. So if you have any questions, you can pop them in the chat box. And when we are done, I will do my best to answer them as best as I can. If you feel at any point that you do not understand or you are confused, please raise your hand or pop it in the chat and I will go back to the previous slide or to where you are confused or maybe lost, and we can take it again from the beginning. All right. Okay, so when we look at harassment, we have to start at the beginning. So what is harassment? All right. So harassment is a form of unfair discrimination. And it comes from the Employment Equity Act, which was developed to promote equal opportunity and fair treatment and to eliminate unfair discrimination. So in March 2022, we had a code of good practice that came about, which is a piece of legislation that all companies and employees have to abide by on sexual harassment. And in this act, or in this code of good practice, it outlines all of the things such as what is harassment. It outlines what we should do in order to prevent harassment and eliminate it, and the processes that one should follow, an employer should follow when harassment has occurred. Okay. So harassment, as I explained earlier, is a form of unfair discrimination that is prohibited on any one or a combination of grounds of unfair discrimination listed in Section 6. So I am picking on you because of something in Section 6. So when we look at Section 6, it is a whole big paragraph of categories, right? So I am picking on you because of one of these categories. It could be your race, it could be your gender, it could be your sex. So I'm just going to read this paragraph out and then I would give you an example. So no person may unfairly discriminate directly or indirectly against an employee in any employment, policy, or practice on one or more of the grounds, including race, gender, sex, pregnancy, marital status, family responsibility, ethnic or social origin, color, sexual orientation, age, disability, religion, HIV status, conscience, belief, political opinion, culture, language, birth, or any other arbitrary ground. So when we look at harassment and defining harassment or trying to understand or establish whether it is harassment or not, one of the things that we look at is whether what the person is picking on you about. So am I picking on you because of your gender? Am I picking on you because of your race? Am I picking on you because of your age? It has to come from this paragraph. So I'm picking on you because of something in this paragraph. So when we look at the categories based here, most of them are pretty straightforward. But there is one that I do get a question about, and I've had this question many times before, is conscience. And the question is, how do you discriminate against someone based on their conscience? So when we look at conscience in terms of this code of good practice, what they're stating is, I'm picking on you, I'm discriminating against you based on what you morally believe is right or wrong. Okay, so to give you an example of this, when we look at, it's just an example. So when you look at living with your partner before getting married, right? So some people, like myself, would believe that that's perfectly okay to live with your partner before getting married. However, there is, and it's most probably in some of the older generations that do believe that you have to be married before living with your partner. Okay, so I morally believe that living with your partner before marriage is perfectly fine. I believe that it is right. Let's just state my manager or someone else knows that this is what I morally believe is right, and they disagree. So they think that, no, you have to be married before you live with your partner. And they pick on me or they discriminate against me based on what I believe is right or wrong. Okay, so that is what discriminating against someone based on their conscience would look like. Okay, so when we look at harassment, harassment has always been around. Okay, when we look at examples, we can look at gender-based violence. It's always been a topic of discussion, and it's always been an employer's responsibility to protect employees. Okay, so these are just some of the other acts that impact harassment and how employers or organizations should be protecting their employees. So it wasn't always the code of good practice. It's not something new. It's just that this code of good practice specifically aligns itself with dealing with harassment and the prevention and elimination with harassment. That does not mean that it never was in place. Okay, it was always there. We always had to do our best as employers or as organizations to protect our employees. And these are just some of the other acts or legislations that deal with the prevention of harassment in some aspect. Okay, so an example would be if you look at the Occupational Health and Safety Act. As employers or as companies, it is their responsibility to provide a safe and healthy working environment. So that would mean the elimination and prevention of harassment. However, it does not specifically only deal with harassment. There are other aspects in that act, but there is a point of preventing and eliminating harassment in that act. Okay, so moving forward, these are just some examples of harassment. Slandering an employee or spreading rumors maliciously, conduct which humiliates, insults, or demeans an employee, sabotaging or impeding the performance of work, intolerance of psychological, medical disability, or personal circumstances, surveillance of an employee without their knowledge and with harmful intent, use of disciplinary or administrative sanctions without objective cause, explanations, or efforts to problem solve, abuse or selective use of disciplinary proceedings, pressuring an employee to engage in illegal activities, pressuring an employee to resign. So these are just some generic examples of what harassment would look like. Okay. So now that we know what is harassment, we then move on to the next step. Okay. So this is dealing with harassment in the workplace. So the next step is defining who is an employee. So when we look at who is an employee, a lot of the answers that I would receive is it's someone that has a contract of employment, which is correct. It is someone who is on the payroll. It is someone who gets paid for services that they provide to the organization, all right? But when it comes to harassment and specifically to the code of good practice, an employee includes applicants for employment and volunteers who assist in any manner in carrying on or conducting the business of an employer. So amongst the people who have contracts of employment, the people who are on the payroll, the people who provide services to the organization, an employee also includes applicants for employment, so someone who comes in for an interview, and volunteers. So anybody volunteering, so they don't usually get paid, so they're not on the payroll, but they are providing a service to the business. So when we look at harassment and the prevention of harassment, an employee includes these individuals. Okay. So now we look at who can be a victim. It is important that when we look at who can be a victim, we also look at who can be a perpetrator. So this list that you have in front of you on the screen, these are the individuals that can be a victim, but these are also the individuals that can be perpetrators of harassment. Okay, it works both ways. So these individuals include owners, employers, managers, supervisors, employees, as I explained earlier, job seekers and job applicants, persons in training such as interns, apprentices, and persons on learnerships. It includes volunteers, clients and customers, suppliers and contractors. So it includes contractors, it includes clients and customers. So as an employer, it is our responsibility or your responsibility to prevent and eliminate and protect your employees from harassment from all of these people, as well as to educate your employees so they are not the perpetrators of harassment. Okay, anybody that has dealings with the business can be a victim or can be the perpetrator. So that's a very important point to note. So anybody that can be a victim can also be a perpetrator. So we know who is an employee, we know who can be a victim, we know who can be a perpetrator. Now we need to know, where are employees protected from harassment? The easiest way to remember this for myself and for some of the other people that I have done this training for is, anywhere that work has put you, you are protected by your employer. All right. So if you are on a conference for work, you are protected. All right. If you are on a work-related trip, you are protected. If you are on a WhatsApp group that is solely for work purposes, you are protected. Okay. A nice example to use, which I have used before, is let's just say that you have a conference in Johannesburg and your company has sent you there. Let's just say it starts Monday morning at 8 o'clock and you're going to be there for the whole day, and you are actually from Durban. So in order for your convenience, you decide, no, I'm going to go on the Sunday afternoon because it starts at 8 o'clock. And if I take an early morning flight, it's going to be a bit too hectic. So you leave the Sunday afternoon, you board your flight, everything is fine. You get to your hotel or where your accommodation, and you checking in, and let's just say the receptionist is a little bit too friendly with you and obviously makes you uncomfortable, and it leads to harassment. Okay, are you protected? Yes, you are, because the only reason that you are there on that day is because of work. You are not there for personal use. You are there because work has put you there. Therefore, you are protected from harassment. Right? So in that instance, what you would do is you would send the complaint off to whomever is your designated person, whether it is your HR manager or your line manager, and you would say, this is what has happened, and they would take it forward from there. Okay, so just to go through the slide, you are protected at the workplace, places where people are paid to take rest breaks or meal or use the sanitary washing or changing areas, work-related trips, traveling, training, events, or social activities. A really good point to note is that when it comes to things like Christmas parties, when it comes to things like team building or any event where it is work-related, you are protected. Okay, so for those of you who believe that you're not protected at Christmas parties, you are actually protected and you should be on your best behavior. Okay, so anything else such as work-related communication, as I explained, WhatsApp groups, if you are on a WhatsApp group for work-related information, you are protected. Employer-provided accommodation. So for example, as I said, you went to Johannesburg and you stayed at a hotel, you are protected there. You are protected in any work transportation. So I do remember when COVID-19 first came about, there was a lot of individuals who had used work-related transportation. So you are protected in that instance. And the location where you work, if it is not your employer's premises. So if you work on site, so let's just say you're in construction and you don't work at your premises or at your office, you work at other places, you still are protected. Remember, the question here to ask yourself is, am I here because of work? If the answer is yes, then you are protected, right? So when dealing with harassment, it does deal with a lot of emotions and it can be really subjective. So as employers or as HR individuals, it is our responsibility to try and define what harassment is, okay? And what constitutes as harassment and what does not. So the Code of Good Practice does assist us in this, and we have created a 3-point test as what I'd like to call it. Okay, so the first thing we look at when we receive a complaint of harassment is One, whether the conduct was unwanted, which impaired a person's dignity, okay? So was the conduct unwanted? Did it show in any way that the person was uncomfortable with it? Did the person say that they were uncomfortable with it? Or should the person, the perpetrator, have known that this is not okay and this is not appropriate behavior for the workplace? Secondly, it impaired the dignity of the individual or of the victim. How did it make that person feel? Did it make them not want to come to work anymore? Did it make them scared? What exactly happened? Secondly, we look at, did it now create a hostile or intimidating work environment? Okay. Did it create a hostile and intimidating work environment for one or more of the employees, or has the effect of inducing submission by actual or threatened adverse consequences? So what type of environment did it now create? Okay. And the last thing we look at, if you remember section 6 is really important because those are all of the categories that I can, where you would discriminate against someone and it would constitute as harassment. So is it related to one or more of the grounds in section 6? So what am I picking on you about? Which category is it related to? So it has to relate to one of the categories in section 6. Okay. So if all of these answers state, yes, it was unwanted, yes, it did impair the dignity, yes, it did create a hostile and intimidating working environment, yes, it related to, for example, let's just say the gender of the person, then we would proceed with the process of conducting the investigation on harassment and take it from there, right? Harassment includes violence, physical, psychological, emotional, sexual, gender-based, and racial abuse. Okay, it can be physical force or power, whether threatened or actual, against another person or persons. So it doesn't need to be I'm physically threatening you or I said something. It can also be whether I'm inclined to threaten you or I'm inclined to harm you if you do not do something, or etc. So when we look at unwanted conduct, the criteria of harassment involves unwanted conduct distinguishes harassment from acceptable conduct. So when we look at what is unwanted conduct, the first thing we do is, did the complainant or the victim communicate to the perpetrator that this conduct is unwanted? Okay. So this can be verbal, non-verbal, directly or indirectly. So in this instance, did you show the person that the conduct is unwanted? So let's just say if you have an employee that brings you flowers on a daily basis and you are not happy with this, did you show in any way that you do not want this? Did you say, no, please stop doing this? Did you, every time he brought you a flower or she brought you a flower, did you throw it in the bin? What exactly did you do to show that it was unwanted? So it can be verbal or non-verbal. I can specifically communicate and say, I'm not comfortable with you giving me flowers every day. Please stop doing that. Or I can take the flowers and throw it in the bin right in front of you and make a look of disgust on my face. So that would be non-verbal. So whether directly or indirectly, so I can tell you to your face, okay, I do not like this behavior, or indirectly, I can perhaps have a friend to assist me or co-worker that I trust or I can confide in, or the designated person at your company who assists with harassment to state, okay, can you please inform this person that I'm not comfortable with this behavior, because maybe you're a bit scared because it could be a manager, it could be someone higher than you. That is also acceptable. So you have to show that the behavior is unwanted, all right? If there is no communication, so if you did not communicate that the behavior is unwanted, what needs to happen is we need to determine, so the HR person or whoever is in charge of handling your complaint would determine whether the conduct was such a nature that the perpetrator should have knew that it was unacceptable. So, for example, bringing a coworker flowers, that may be okay. Maybe you thought the coworker gave you the wrong signals. I'm not sure what happened there, but she did inform you, okay, she did not like it. But I shouldn't need to tell you that you cannot come to work, that you shouldn't be giving people massages at work. right? I shouldn't need to tell you that you should not be touching people appropriately at work. You should know that you're not allowed to do these things, okay? So in those instances where you've touched someone inappropriately or made a inappropriate comment, you should have known that it was unacceptable. So the person would not necessarily have to tell you that what you did made me uncomfortable, because you should know you're not allowed to touch people at work. So that's just an example. Okay, so the next thing we look at when we look at unwanted conduct is whether or not the conduct constitutes harassment should be assessed on an objective basis from the perspective of the employee who alleges harassment. A reasonable person still applies. Okay. So when we look at a reasonable person, the best way to explain this is with an example, right? So let's just say you have an individual or a lady, and she deals with customers or clients, okay? She stayed up on a Friday night working late to assist this customer or client out of a big problem that they had, and she eventually managed to resolve it. The problem was not caused by her, but she did manage to resolve the issue, and she stayed up working, let's just say till 11 o'clock that night, and resolved the problem. Monday morning, when she comes to the office, as a kind gesture or a show of appreciation, the client then sent her a bunch of flowers just to say, thank you for assisting me out of this jam. And then what happens is she goes to HR and says, no, this is harassment, right? So when you do an investigation into it, and let's just say HR did the investigation and they said, okay, what is actually going on? Because what it looks like is flowers were sent because you assisted a client and they just wanted to show their appreciation and thanking you for assisting them. After an investigation, the HR finds out that this specific employee, the specific lady, comes from a very abusive relationship where she wasn't really concerned. It wasn't actually about the flowers. It was more about how is she going to take the flowers home? What is her partner, husband, boyfriend, whatever you want to call it? What are they going to say? Because when she goes home, they are going to start questioning her and basically interrogate her. Who sent you the flowers? Why are they sending you flowers? And it's going to sent her into a state of anxiety and panic. So she went to HR and she said, okay, no, it's harassment. So in that case, it would not be harassment, because a reasonable person, if it was any other person that received the flowers who did not come from that background or who did not have that traumatic relationship back home, they would have taken the flowers and they would have gone home, or they would have just left the flowers in the office. They wouldn't have bothered much about it because it's just a token of appreciation from the client. However, in this instance, because of that relationship that she had, she went into a state of panic and trauma, and that's what caused her to lay the complaint. All right. So when looking at unwanted conduct, we also need to look at it from an objective basis, and we also need to see, is this a reasonable person or is it not a reasonable person? And you need to do your investigation in order to find out what exactly has occurred. All right. So we're going to move on. I hope everybody is with me so far. When we look at harassment, it can happen once or it can be repeated events, all right? So harassment does not have to occur on repeated events. It can happen once and it would constitute as harassment, or it can happen on multiple escalating events, all right? The easiest way to explain it is sexual harassment. If someone touches you inappropriately, it needs to happen once to constitute as harassment. Or if we look at a repeated events, we look at bullying. So bullying, for example, can be an escalating process, right? So it can start off something as small as gossiping with your coworker. Then maybe it leads to a WhatsApp group or Teams chat being formulated. And then from there, it leads to comments being made as the person walks by. Then from there, it leads to excluding them from social events or work-related social events, or excluding them from information that they need to perform their duties. Okay, so it is repeated events or escalated events that can lead to harassment. Okay, so bullying is considered as a form of harassment. So when we look at workplace bullying, the things that we look at is the context of harassment. We look at the circumstances of the complainant and the impact that it had on him or her. And we look at the respective positions of the victim and the perpetrator. Okay, was it a manager and an employee? Was it two co-workers? Was it a line manager and the CEO? Okay, what was the positions? What had happened, right? And what is the circumstances around it of the complainant and what impact has it had on him or her? How did it impair their dignity? Did it create a hostile working environment? What was the consequences of this harassment? All right. So when we look at bullying, as I explained before, it is an escalating process where the complainant ends up in an inferior position and becomes the target of systematic negative social acts. So as I explained, it's comments being made, it's exclusion from work-related social activities, it's exclusion from divulging of work-related information that they could use to perform their duties, etc. When we look at the types of harassment, there is physical harassment, which is physical attacks, simulated or threatened violence or gestures. It is verbal bullying, so it can include threats, shaming, hostile teasing, etc. Or it can include psychological harassment, which is emotional abuse. All right. So we've discussed harassment, we've discussed how to objectively identify when harassment has taken place. We're going to now move on to sexual harassment. Okay. Sexual harassment is the form of unfair discrimination and is prohibited on the grounds of sex, gender, or sexual orientation. So if you look at our section 6, our big paragraph with all of our categories, sex, gender, and sexual orientation comes from section 6. All right. So how do we differentiate between these? Sex is what you biologically are. Gender is what you identify as, and sexual orientation is who you are attracted to. Right? Same-sex harassment can amount to discrimination on the basis of sex, gender, or sexual orientation, and gender-based harassment. Sexual harassment is unwelcomed conduct of a sexual nature, whether direct or indirect, that a perpetrator knows or ought to have known is not welcome. So when we look at sexual harassment, for harassment to constitute as sexual harassment, it has to be related to sex, gender, or sexual orientation. Then only is it sexual harassment, right? It can be indirect or direct, and it is an unwelcomed conduct from the perpetrator. So when we look at sexual harassment, it may be offensive to the complainant, make the complainant feel uncomfortable, or cause harm or inspire the reasonable belief that the complainant may be harmed. It may interfere with the work of the complainant, although it not need so, right? So it may interfere with the work or it may not interfere with the work of the complainant. However, when we look at sexual harassment, it makes the person feel uncomfortable. It does not need to necessarily harm the in-person, but even if it inspires the belief that the person may be harmed, it would constitute as sexual harassment. These are just some examples of sexual harassment. We look at all unwanted physical conduct, ranging from touching to sexual assault, following, watching, pursuing an employee, sexual attention, advances or proposals, or other behavior, whether explicit, including suggestions, messages, advances, attention, or proposals of a sexual nature, implied or expressed threats of reprisal or actual reprisal to comply with sexual orientated requests, advances, attentions, or proposal. It includes verbal conduct such as unwelcome innuendos. Non-verbal forms of sexual harassment includes staring, unwelcome gestures. It can also include victimization, a quid pro quo, sexual favoritism. Another example would also be sexual jokes. Sometimes sexual harassment can come from sexual jokes. Okay, so when we look at sexual harassment, how do we establish sexual harassment? How do we know it is sexual harassment or sexual harassment has occurred? There are three things that we look for. Is one, was the conduct unwanted? Two, the nature and the extent of the conduct, and three, the impact of the conduct. So when we look at unwanted conduct, this can be either shown verbally or non-verbally, such as walking away or not responding. The complainant may request someone else to intervene. So as I explained earlier, if you feel uncomfortable or out of fear, you don't want to approach this person, the perpetrator, you can ask a co-worker or the HR individual or even your manager to go in and state, this is not acceptable, please stop doing this. So they will approach the perpetrator and tell that the conduct is not wanted, it does not mean that sexual harassment has not occurred. So remember, we need to understand and we need to investigate. Should the perpetrator ought to have known what they have done was not acceptable. As I explained earlier, you should know that you're not allowed to go around touching people inappropriately. Everybody knows that. Well, I hope everybody knows that. Whereas sexual jokes, sometimes an individual may not know that that's not appropriate because people have laughed about it. Like if you're standing in a group, everybody is laughing and they obviously did not see a problem with it because everybody accepted it. So in that instance, you would go in and you can ask someone else to intervene, or you would do your investigation to find out what exactly occurred. The next thing we look at is the nature and the extent of the conduct. So as I explained earlier, the conduct itself must be of a sexual nature and it must be related to your sex, your gender, or your sexual orientation. This can include physical, verbal, or non-verbal conduct. It may include victimization. A single incident of unwelcome sexual conduct may constitute as sexual harassment. So as I explained earlier, sexual harassment can be a single incident, or it can be repeated events or an escalation of events. Okay. Lastly, we look at the impact of the conduct. So what has happened? All right, what is the circumstances of the employee? What are the respective positions of the employee and the perpetrator in the workplace? Was it between a manager and an employee? Was it between two co-workers? Was it perhaps between an intern and a manager? What exactly happened? What are the positions of the individuals and what effect has it had on the victim's dignity? All right. So now we move on to racial, ethnic, or social origin harassment. So when we look at racial harassment, there are two other categories that come into this, which is ethnic or social origin. All right. So this is related to a person's membership or presumed membership of a group identified by one or more of the listed prohibited grounds or characteristics associated with such group. Right. So when we look at racial harassment, racial, ethnic, or social origin, it's not just about race. So I'm not just picking on you. So it can be about race, or it can be about something like, let's just say, I like South Africans and you are European and I don't like you, so I'm going to pick on you because you are European. Right. Or let's just say, because you isiZulu, an example, I'm picking on you because of that. All right, so it doesn't have to be because you're black, white, Indian colored. It can be because of your ethnicity, or it can be because of your social origin as well. Okay, so it is unwanted conduct which can be persistent or a single event that is harmful, demeaning, humiliating, or creates a hostile working environment. It includes direct or indirect behavior, which involves issues such as racist verbal and nonverbal conduct, remarks, abusive language, racist name calling, offensive behavior, gestures, racist cartoons, memes, or innuendos. So it is important to note that a test is applied to identify whether the language is racist and whether it is reasonably capable of conveying a racist meaning to the reasonable hearer. All right. So these are just some examples when we look at racial ethnic and social origin harassment. It can be abusive language and racist jokes, racially offensive written or visual material, racist name calling or negative stereotyping, offensive behavior, a subtle or blatant exclusion from the workplace, threatening behavior which intimidates a person or creates a hostile working environment. So when we look at establishing racial harassment, this is the test that we do. The first thing we need to know is whether the language or the conduct complained of is abusive, right? The next thing we look at is whether the language or the conduct impairs the dignity of the complainant or complainants, whether the language or conduct is directed at a particular employee or group of employees, the extent and the degree of abuse or impairment on the person's dignity, and lastly, the impact of the conduct. So an example of racial harassment, or to distinguish what is harassment and what is not harassment, would be, let's just say you had a trainer that came in to train you on harassment at your workplace, and she was Indian. And you saw her in a group, let's just say you were in a restaurant and you saw the lady there and you were like telling your friend or your coworker or whomever, there you go. That's the Indian lady that did our harassment training at work. So would that language be abusive or not? So that would not constitute as abusive language because it is being used as a descriptive measure for that person. Okay, so maybe they were in a group of Indian females, or sorry, maybe they were in a mixed group of individuals and she was the only Indian out. So that's why they said, okay, that is the Indian lady. But if I said, there goes that Indian bleep that did our training, that would be considered as abusive, right? Okay, so moving on, we've discussed what is harassment, we've discussed who is protected, where you are protected, we've discussed sexual harassment, racial harassment, we've discussed the tests that we put in place to objectively establish harassment. Now we're going to move on to the employer's obligations, right? So as I explained before, the Code of Good Practice assists employers and outlines what the employer needs to do in order to prevent and eliminate harassment in the workplace. Okay, so the first thing employers must do is an assessment of the risk of harassment, all right? So I'm not sure if most of you are aware what a risk assessment is. It's used in health and safety quite often. So the first thing the employer needs to do is conduct a risk assessment on harassment in the workplace, right? The second thing that employers need to do is have a zero tolerance policy on harassment, right? So I'm not sure whether you have a policy yet, or maybe it's still being drawn up, but your employer should have a zero tolerance policy on harassment, and they should have a policy and procedure in place on harassment and how they deal, or the process of dealing with harassment, okay? Next, the employers should attempt to ensure that persons such as customers, suppliers, job applicants, and others are not subjected to harassment by employees or any other person representing the employer. So they need to ensure that no one else is a victim by the employees of the organization. And that is what they're trying to do by informing employees and training employees and making employees aware of harassment, what it is. There's a policy, there's training to be held, etc., so that they know what behaviors are appropriate and what is not appropriate. At the same time, employers should attempt to ensure that employees are not subjected to harassment by third parties, such as clients and suppliers or anybody else that have dealings with the employer. So the employer must do their best to protect all of their employees. So they need to ensure that their clients or their suppliers or their customers, whomever, whichever third party that they're dealing with, is aware that they have a zero tolerance policy on harassment, and these are the acceptable behaviors and or not acceptable behaviors, etc. Okay, the next thing that the employer should have is the policies and procedures. So as I explained earlier, your company or your employer or your organization should have a policy and procedure that outlines a clear statement of the employer's position on the prevention and elimination of harassment, as well as it should outline the procedure of what should happen when you have been harassed. Okay, so it should tell you, okay, you go to your line manager first, or you go to your designated person first, or you go to HR if you have a complaint of harassment, all right? Lastly, harassment policies should be communicated effectively to all employees. Your employer should make you aware that there is an harassment policy, whether it is sending out an email to let you all know that there's a new harassment policy in your policy guidebook, or whether it's them sending you an email with the policy attached, whether it's training and providing awareness on the policy for all employees, but they should communicate this policy with all employees. So when we look at the policy itself, it must comply with the code of good practice. It must specify the procedures that must take place where harassment is alleged to have occurred. It must state if there is any available counseling or treatment or care support programs, etc. So if your company does provide counseling on all of that, it should state it in the policy. The employer should implement ongoing awareness programs. So awareness programs can be training of employees. So employees should be trained on harassment. They should be trained on what is harassment, how they are protected, who can be a victim, a perpetrator, etc. They do need to be trained on that. And lastly, employers need to take appropriate steps if harassment has occurred. So they need to do their best to effectively try to eliminate it and prevent it from happening again if it has occurred. Okay, so when we look at reporting harassment, an allegation of harassment must be immediately brought to the attention of the employer. So as soon as it has happened, you need to take it to your employer, to your HR, to your line manager, whomever is your first point of contact as outlined in the policy. Secondly, it must be investigated and appropriate actions or steps must be taken. Okay, this may include disciplinary action for the perpetrator. All right, so once you have taken this complaint to your HR or your line manager, it needs to be investigated. So as I explained earlier on, the 3-point test needs to be done. It needs to be investigated. If there's any camera footage, you would look at the camera footage. If there's any witnesses, you would question the witnesses and find out exactly what has happened. Okay. So when we look at the procedures of how to deal with harassment, these procedures should enable a resolution in a sensitive, confidential, efficient, and effective manner. So everything dealing with harassment from the time that you lay your complaint should be kept confidential, all right? Because it is a very sensitive topic. Okay, so when alleged harassment is reported, the employee is obliged to investigate and advise the complainant of the informal or formal procedure to be followed. Where an incident has occurred, this must be immediately brought to the attention of the employer. So there's two procedures that can be followed when it comes to harassment. It is the informal or the formal procedure. So just to give you an example, an informal procedure can be, let's just state, if the flower example that I gave you earlier, I have a coworker that is continuously bringing me flowers and I'm not okay with it. I've spoken to them and I've told them I'm not happy with it and they still continue to do it. So I have gone in and I've laid a complaint of harassment. So an informal process can be where they interview me or they set a meeting with me and ask me what exactly has happened. So I tell them this is what happened and they say, okay, what would you like? So I don't want any disciplinary action to be taken at this point. I just want the person to stop doing what they're doing, right? So the HR or the manager who is handling the situation, they can then, after they've done the investigation, After they've done the test and they've seen that it actually is harassment, they would go in and they would call in the perpetrator and they would say, okay, this has been brought to our attention. She has informed me that, you know, she's not happy with this, and she's told you she's not happy with this, and you continuously persist to do this. We would like you to stop. If you do not stop, disciplinary action will be taken. All right, so that is an informal process. However, I would urge an employer, if it is an informal process, to still document it, because sometimes people tend to forget what has happened, and their memory is very, very bad, and they forget that you've had the conversation with them, or they forget what you've said to them. So even if it is an informal process, just document it to say, this is what happened, this is how we resolved it, and you just keep it away in a file just to state that it has been dealt with. All right. So even if the complainant or the victim states that they want no disciplinary action to be taken, right? So if I come and say, okay, you know what, I just want them to stop, I don't want any disciplinary action to be taken. If the employer deems that the behavior was unacceptable to an extent where disciplinary action needs to be taken, they can still proceed with disciplinary action, right? Because remember, it's their responsibility to protect all of the employees and to eliminate harassment as best as they can. And if they feel that sitting down with the perpetrator and just saying stop doing that is not enough, and maybe the perpetrator needs a warning, or maybe it's something worse, or the situation was something worse where the perpetrator goes into a disciplinary hearing, the employer can decide the disciplinary action that is to be taken depending on the severity of what has happened. Okay. So we're going to move on to the obligations of the employer. So as I explained, when the harassment has been brought to the attention of the employer, the first thing they need to do is consult the relevant parties. So they would consult the victim and they would do the investigation, establish that harassment has taken place, and then consult the perpetrator. Okay. Secondly, they need to take the necessary steps to address the complaint. So they would either do an informal process, they would do a grievance procedure, or they would go into a disciplinary procedure depending on the severity of what has happened, right? And lastly, the employer would need to take steps to eliminate harassment and ensure that this does not occur again. So they can send them on additional training or on harassment or whatever they deem that is necessary to try their best to eliminate harassment from taking place again. Failure to take steps to eliminate harassment once the allegation has been brought to the attention of the employer will render the employer liable for the conduct of the employee. This is the case even if it is one incident. So remember, harassment can be one incident or it can be repeated events. Sorry. Okay. So the other thing the code says, or the other point the code of good practice makes, is that an employer should appoint a designated person. So this person is the person who needs to be trained on providing counseling, advice, and assistance. They should know the harassment policy quite well, because in the case of harassment, the complainant can go to the designated person to seek advice, to seek counsel, or to find out more about what the policy is or what the procedure is on how to rectify the situation, right? This person, this designated person, needs to be adequately trained and given appropriate resources. So if you designate a person that does not have the skill set, so they do not know how to provide counseling in the workplace or advice or assistance, you would need to provide training and appropriate resources so that they can inform and guide employees effectively. Okay. Someone must always be available to explain to the complainant both formal and informal procedures. So this would be your designated person or your HR individual who would explain the formal processes or informal processes that the employee may follow. It is important to note that the code does mention that an informal procedure may be followed before a formal procedure. So as explained earlier, what an informal process is, this can take place before a formal procedure has occurred, right? So remember, the whole point of this is we want to provide a safe working environment. We want to provide a productive working environment. So we want to find a resolution. We don't want to just go straight into the disciplinary process. We want to say, okay, what has happened? What is the severity of what has happened? What is the impact? What type of environment has it now created? Is it not productive anymore? Is it hostile? What has happened? And if the employer says, okay, it can be resolved at an informal process level because it's not severe, then that would take place before the formal process. But if it is so severe that you would need to go into a disciplinary hearing or grievance hearing or whatever the case may be, you would follow the formal procedure, right? So the formal procedure is when we look at a grievance, this must be investigated. So the complaint must be investigated, and the employer must investigate depending on the case and depending on what has happened. As I said, the severity, they may take action regardless of the complainant's wishes. So like I explained earlier, if I was a victim and I said, no, I just want the person to stop, I don't want them to be given warnings, etc., but the employer deems that the issue is or what has happened is so severe that it warrants a warning, the employer can proceed to take disciplinary action. All right. The policy and procedure that you have, so your company, as I explained earlier, must have a policy and procedure in place that deals with harassment. This policy and procedure must outline the grievance process and the disciplinary process that is to be followed, as well as the time frames that is allowed. All right. It should also specify what happens if the matter is not resolved satisfactorily internally. Next, the disciplinary process must specify the range of sanctions. So when we talk about sanctions, it is a punishment. It can be a verbal warning, a written warning, a final written warning, or a disciplinary hearing, which could lead to dismissal. But your disciplinary process must specify the range of sanctions that could be imposed upon a perpetrator. Confidentiality, as I explained earlier, this is a very sensitive topic. So you have to maintain confidentiality throughout the entire process. Okay, the next thing we look at is sick leave, right? So the code encourages employers to provide additional paid sick leave if the complainant has exhausted their sick leave. Okay, this is not an obligation to the employer, right? The code encourages it. So the code basically states, or the legislation states, if you can, so if the employer can provide additional paid sick leave, then they should do so, right? However, if they cannot, they can obviously go to UIF and claim illness benefits if they have exhausted their sick leave. So now remember, when we look at additional paid sick leave, where the employee requires trauma counseling. So it's something so severe that the person has to now go for trauma counseling and they need additional sick leave for the trauma counseling. So they request it from the employer. Okay. Once again, this is not an obligation from your employer. They do not need, it's not as per legislation that they have to provide you with additional paid sick leave. It is where possible. It is a scenario where if it is possible and the employer can provide additional sick leave, they should do so as the legislation encourages it. But if they cannot and you have exhausted all of your sick leave, you can claim from the illness benefits via UIF. Okay, we're almost to the end. I see that we have 5 minutes more. What happens once the sexual harassment has occurred? Any employee who feels that he or she has been unfairly discriminated against or that an employer has contravened the laws may lodge a grievance in writing with the employer. The matter may thereafter be referred to the CCMA if the issue cannot be resolved at the workplace. Okay, so now remember, as an employer, you have timeframes in place, you have a grievance procedure in place, you have an informal procedure, a formal procedure, you have disciplinary procedures in place, all of these to help you when harassment has occurred. Okay, so if you do nothing, as an employer, if you do not follow these procedures, if you do not investigate, if you just let the complaint be, the employer can take it to CCMA and say, I've reported it to my employer and they have done nothing about it, right? So as an employer, it is your responsibility, once the complaint has come in, to investigate and to follow the procedure as outlined as per your policy, all right? When it comes to the employee or someone or the victim, my suggestion to you is always follow internal procedures first before going to the CCMA. Only if it cannot be resolved at the workplace, then you would go to the CCMA, because what would happen in that instance, if you go to the CCMA without following procedure, the first thing the commissioner is going to ask you, or the first thing the employer is going to bring up at conciliation or con up, is that the internal procedures was not followed. All right. So please follow your internal procedures first, and thereafter, only if it is not resolved, you would then go to the CCMA. If the CCMA is not able to resolve the dispute through conciliation, the matter can either be referred to arbitration if the employee earns less than the amount set as per the Basic Conditions of Employment Act. If the employee earns above the amount, the matter may be adjudicated by the Labour Court. However, in these circumstances, if both parties agree to in writing, the matter may be arbitrated by the CCMA, right? In sexual harassment matters, the employee has a choice between arbitration at the CCMA and adjudication at the Labour Court, regardless of how much he or she earns, right? So this instance would be if it is not resolved satisfactorily in the workplace, or if the employer has not done anything about it in the workplace, this is what would happen next, right? So we've come to the end. I'm not sure if there's any questions. We do have, I think it's about 3 minutes left. Is there any questions? Okay, so there was a question about the recordings. The recording will be shared and the slides will also be shared. All right. Thank you so much for joining me today. I hope you all have a wonderful Wednesday afternoon and rest of the week. All right.